This is a meeting of the Coral Gables South Dade Estate Planning Council. I am Tania Sotelo, your secretary this year. I am an estate planning attorney in Coral Gables. And tonight we have a wonderful speaker. Our speaker this evening is a board certified trusts and estates lawyer and is the founder of the Clearwater, Florida law firm of Gassman, Crotty, and Denicolo, PA, a six-lawyer firm focusing on the representation of high net worth families, physicians, and business owners and their companies in estate planning, taxation, and business and personal asset structuring. Our speaker this evening is Alan Gassman. Mr. Gassman is the lead author of many books, including Bloomberg BNA's Estate Tax Planning in 2011 and 2012, Gassman and Markham on Florida and Federal Asset Protection Law, The Estate Planner's Guide to Bankruptcy, Florida Law for Tax, Business, and Financial Planning Advisors, 8 Steps to a Proper Florida Trust and Estate Plan. He is a frequent speaker for continuing education programs, has published well over 200 peer-reviewed articles with publications such as BNA, as mentioned, Florida Bar Journal, Leanberg Information Services, Trust and Estates Magazine. He is also a past president of the Pinellas County Estate Planning Council and will receive or has received the Estate Planners Hall of Fame designation as an accredited estate planner distinguished this year. He has also co-chaired over 40 Florida Bar continuing legal education programs, including over 15 years each for wealth protection and representing the position, and is the co-creator with Professor Jerry Hesh of Estate View Software. Mr. Gassman holds a law degree and a master's of law degree in taxation from the University of Florida and a business degree from Rollins College. Mr. Gassman is board certified by the Florida Bar Association in estate planning and trust law, has the accredited estate planner designation from the National Association of Estate Planners and Council, and has maintained an AV rating from the Martindale-Hubbell service for over 20 years. He is also listed in both Best Lawyers in America and Florida Super Lawyers.
So it looks like I'm going to talk for about 40 minutes, and then I'm going to check for questions. So I'm hoping for a lot of good questions. Whatever the question is, please just make sure about 7:10 interrupt me and tell me if there's any questions. Please make them easy, make the questions easy or make them interesting. There's no way to really cover the nuts and bolts of creditor protection in 50 minutes, but I can cover a lot of nuts and a lot of bolts, and we can have some fun while we're doing it. I've given each of you a PDF of my most recent book, which is what CPAs and other advisors need to know about bankruptcy. It was what attorneys and estate planners need to know about bankruptcy, but I got a CPA to help me rewrite it. His name is Ken DeGraw, and we had to change the word estate planner to CPA in a whole bunch of different places in the book to make this happen. If you want the estate planning edition, just send me an email and I'll be glad to send you the estate planning edition. And we're always looking for suggestions on how to make our books better. And it's a lot of fun to write these, quite honestly. We also have a Thursday report. If you want to get our free Thursday report, it's on some Thursdays, not all Thursdays, and sometimes it's a little late. Sometimes you get it on Friday, but we do have that there. Then we have a lot of videos on our YouTube channel. So if you're interested in estate tax planning or charitable planning, you may find a lot of information there. Now, the first thing I like to talk about when you talk about estate plan, creditor protection planning, is that people need it and they don't realize they need it. So it's sometimes a good idea to share stories. So the one story that I think is interesting, 2016, but still pretty instructive, a lady takes her daughter to go to Target, and her daughter picks up a hypodermic needle in the parking lot, and the lady goes to bat that needle out of her daughter's hand and gets stuck. They go to the emergency room. The lady has a shot for tetanus and has a very bad reaction and asked Target for a settlement. And Target rejected a $12,000 settlement offer the morning of the trial. And the jury gave the lady and her daughter $4.6 million. So, you have clients. I had a client who had a shopping center, and in the shopping center was a bar. And inside the bar was some mean people, and it turns out somebody was shot and killed outside that bar. And they sat my client down for a deposition and said, "You're the landlord, right?" "Yeah, I am." "Did you know the bar was unruly?" "No, I didn't." "Did you commonly pick up trash from the outside of that bar, like beer bottles and things like that?" "Well, yes, I did." "Well, then you should have known that the bar was unruly." The man's carrier paid $2 million to settle the claim, but the landlord should have known that the bar was unruly and should have prevented the murder of somebody outside of his bar. So these stories go on. People say, "Well, I'm not worried about my building. I'm a landlord. I'm not going to get sued above a $3 or $5 million umbrella." Well, how about this verdict for $148 million? I can tell you one story. A client buys a building, brings his client to lunch in the kitchen of the building. There's a terrible storm, and in the middle of the storm, the ceiling falls on the client's head. The client is severely hurt, and it turns out that the ceiling was improved without a permit. So the carrier refused to pay the claim because it was an illegal ceiling. Now, how many of you have clients that would, believe it or not, improve their building without getting a permit? Can you imagine that? No one would do that. So these things happen, and we need to be very attuned to these situations. A car accident, one pizza, cost $10.8 million from a little car accident. So that $5 million umbrella may not be enough. So the first thing is, make sure your clients know, and make sure that you know what will happen if this happens to them. Because I could go on for 20 minutes and tell you real life stories of $20 and $50 million problems that no one ever expected would happen to them. And please remember, it was not raining when Noah built the ark. You got to get this stuff done when you're doing the estate plan. They will come to you when it's too late. And actually, it's never too late, to be honest. But it's much better to get this done in advance and to talk to the client. The client should leave your office knowing what assets are exposed, what businesses are exposed, and what's safe. I don't care if you're a lawyer, a CPA, a financial planner, or a trust officer. I believe that you have a duty to let your clients know what's exposed and what they can do to make those assets less exposed or completely safe. So that brings us to the Florida law. And I know many of you know this, and I know some of you don't or aren't so sure. So I'm just going to go over it the same way I explain it to a client. And like everything we do in our professions, we need to be able to explain things like this in 2 minutes or less, or we will lose the client's attention. So that is known as the elevator speech. Top left-hand side, the safest thing, the homestead, unlimited value, and only up to half an acre if they live within the city limits, up to 160 acres if they live outside the city limits. And our Constitution trumps the fraudulent transfer statute, which means that, notwithstanding that Florida has a 4-year look back, that if you make a transfer to avoid a creditor, the creditor has 4 years to recapture it. With Homestead, there is no fraudulent transfer act. So you could get a $100 million judgment against you for doing some really terrible things. Maybe you murdered a few people, get a $100 million verdict against you. And then the day after the verdict, go and take your previous clean money, not money you stole, but money you've had, and go buy a $10 million house. Maybe you could go buy it in Destin, Florida, and be a neighbor of O.J. Simpson, because that's what he did. And there's no one that is going to be able to touch that house unless they can force you into bankruptcy. And if you have no more than 2 creditors, they can't force you into bankruptcy. So we'll go into more detail, but you can tell clients, and we've had to do this many times, look, life is tough. You've got a terrible problem, but let's go to the worst case scenario. The worst case scenario is we take your $3 million and you're going to sell your house and buy a $3.5 million home. And you're going to put a reverse mortgage on that home, and you're going to live on that home until you can settle with the creditor. Can you survive that? And then the client will say, yeah, I could survive that. Okay, then we'll improve on the worst, but let's just keep in mind that's the worst thing that can happen. So this is why people are calling you from all over the country saying, I'm thinking about moving to Florida. I've got a trial in 6 months to 9 months. Can you help me? What's the situation down there? So the second thing that comes to mind, as long as I can just rant and rave and not necessarily follow my slides, is that you have a great advantage in Florida if you are an advisor in Florida. If you're an advisor in California or Connecticut, you can lose your license if you advise people on how to avoid a creditor. You could be convicted of a criminal offense if you help someone avoid a creditor. In Florida, it's your duty. If you're a lawyer, it's your ethical duty to tell clients what they can do and to help them do what they decide to do. So that's a lot different. And sometimes people have to physically move to Florida before they can get that advice. Because if they're in California, I don't know that I can safely give them that advice or help them. So we live in the only state in the United States where we have these two phenomena. A homestead statute that is not subject to creditor claims, even at the last minute, with a few exceptions, and the actual clear ability to give this advice and the duty to give the advice. So if you don't want to give the advice, that's fine. Refer the client to somebody else. Don't do what a lot of people accidentally do when people come to me 6 weeks before a jury trial and say, well, my son-in-law is a lawyer, does real estate law, and told me it was too late to do anything because I had already been sued. And that's just not the right advice. It's a very interesting area of law, by the way. So we've covered Homestead a little bit. Let's go to what else is completely protected from creditors. IRAs, pension accounts, 401k plans, permanent life insurance, that's universal, cash value, whole life, equity index life, all those are creditor protected if they are owned by the person whose life is insured. A lot of physicians come to me and say, oh, I've got all these life insurance policies on my children's lives and on my spouse's life. Sorry, not protected. You should have put those in a trust or put them in your spouse's name. But that life policy that I own, that's on my life, is going to be creditor protected. Also, variable annuities. And there are very inexpensive variable annuities that can be purchased that are very competitive or much better than CDs. I can buy a CD, it might yield 1%. I could buy a variable annuity and put a short-term bond fund under that variable annuity and yield much more than 1%, defer the tax until I take the money out, and it is absolutely creditor-proof. 529 college savings plans. When you buy a 529 college savings plan for your child, it's really yours. It's considered to be outside of your estate for estate and gift tax purposes, which is wonderful, but it's really yours. You can spend it on yourself. You just pay a little excise tax. So the 529 college savings plan, a lot of clients come to me and say, well, the child is 2, so ratably, I'm putting the money into the 529 plan between now and then, $162.50 a month. No, bang, fund it. Put in the whole $125,000. Put in the whole $150,000. Get it funded now. Get all that investment amount protected from your creditors and growing tax-free. So please put as much as you can in those 529 plans as fast as you can. And there's ways to do that without triggering the need to file a gift tax return. You could have the dynasty trust by the 529 plan, or the family limited partnership owned by the parents could buy the 529 plan. So those are your primary exempt assets. And what does that mean? That means that your client can own these assets before the trouble starts. And then the trouble happens. And then the client can file a Chapter 7 bankruptcy. If it's not mostly consumer debt, if it's business debt, and thank heaven that tort liability is considered to be business debt for bankruptcy purposes. So if less than half of your debt is consumer debt and you have more debt than you can pay, you have the right as an American to go to the bankruptcy court and say, Judge, here's my non-exempt assets. There aren't very many. Here's my exempt assets. Here's the people I owe. Please give me a discharge. I have not made any transfers to avoid creditors within the last year. Please give me my discharge. Now, if the client has made a transfer to avoid creditors within a year before filing for the discharge, they lose the discharge permanently, forever. It is forever gone. The judgment haunts them forever, or at least 20 years. So one thing that when the clients come to you and you say, do you need to make any transfers? It's best not to. Well, yeah, I need to make a few transfers. Okay, well, this isn't going to come to a jury for a year and a half to 2 years. Get that transfer done now, because we may have to file a bankruptcy the day after the jury trial or the week or the month after the jury trial, or at least be willing to threaten this. So now, when I mentioned that B word, the bankruptcy word, I want to mention that even though I've written a couple of books on bankruptcy and I've lectured on bankruptcy, I don't do a bankruptcy lawyer helping me. It is outside of my recognized specialty, and I still don't know what I don't know. So I suggest to you that one of the things that you want to do, or your firm, whatever type of practice you're in, especially if you're a lawyer, you should know a darn good bankruptcy lawyer. And that bankruptcy lawyer should consult with you. Get a fee agreement, give them a retainer, whatever it takes. And when you're in the conference room with the client, you could get that bankruptcy lawyer on the phone and get some advice, or get them to come in and meet with you and the client. Because as we're going to discuss, there's choices. And I want my clients to be well educated on their choices. And there's one other thing I want, and that is I don't want to be criticized by a bankruptcy lawyer later. Let me tell you, you know this. There's 3 ways to do it. They're all equal. You choose path number 1. Then it hits the fan. What's the next lawyer going to say? They're going to say, you should have chosen path number 2 or 3. How did Gassman get you down path number 1? So I want a good bankruptcy lawyer by my side who says, yeah, path number 1 is fine. If that's what you want to do, path number 1 is fine. Now, when it hits the fan, I have a lawyer I can go to who is going to not criticize the decision. He was there, she was there when the decision was made. If they go to a different lawyer, at least we can show we did our very best. So learning as much as you can about creditor protection and then getting help are 2 very important things. Now, another thing I'm going to mention, unfortunately, you have to be very careful about what you put in the file, because there is an exception to the attorney-client privilege, and it is called the crime fraud exception. And you may remember this from law school if you happen to go that day to your evidence course, or finally when you took the bar review course. There's an exception to the attorney-client privilege, and it is if the lawyer assisted in fraud or criminal action. And very, very unfortunately, and as a real surprise, even to many bankruptcy lawyers, The US Supreme Court a few years ago, Justice Sotomayor wrote an opinion that said when you violate the bankruptcy code by helping someone make a transfer that's voidable under Section 521 of the Bankruptcy Code, even though that's not really fraud, the US Supreme Court said that can fall under the crime fraud exception. So there you go. Now the judge is looking at your file and seeing what you told the client. So you have to be careful. You need to get some advice on what you put in the file if you write it down. It is a treacherous area. It's fine when you're doing estate planning and you say, well, Dr. Jones, you're a neurosurgeon. You've been sued a couple times. No one's suing you now. Let me do your creditor protection planning. There's nothing wrong with that. There's nothing wrong with that at all. But Dr. Jones, you're being sued. You have a trial in a year and a half. We've got to decide whether you should transfer these assets out to make it harder for the creditors to find them or whether not to. You've got to be careful about what you put in writing, because what you put in writing could end up hurting the client and end up hurting you. Now, the assets that are difficult for a creditor to obtain. The assets on the left of my chart are creditor exempt. Creditors can't touch them, with very, very few exceptions, which we're going to go over. But then there's other assets that are difficult for a creditor to reach, and creditors will normally settle. And these are LLC and limited partnership interests when your client is one of more than one member, a multiple member LLC, which we'll go over, asset protection trusts, which we'll mention a little bit. But let me tell you, for most of your married clients, married couple clients, they don't need asset protection trusts. Asset protection trusts can be a great fee generator, but really beware of the advisor who only has one hammer and every nail is the need for an asset protection trust. They're usually not needed and they're not well tested. They're not as well tested as we wish they were. So they could be an important part of a creditor protection plan, but not by any means essential. And quite candidly, they are commonly oversold. And then anything a client would do to put assets offshore, it is hard to reach assets offshore. It is mystical. It can be helpful, but it often turns into tax hanky-panky or tax-related reporting issues. So you have to be really careful. And it's not good to, I don't think it's as nearly as good as just putting assets in tenancy by the entireties with a spouse who's not exposed, or buying annuities and life insurance policies and things like that, more conventional planning. And then you have the assets that are exposed to creditors. So the primary word here to learn is the exempt asset. That's an asset on the far left-hand side. I can own it. I can go bankrupt. I can keep it. It is exempt from creditor claims. Charging order protection is when Candace owns 5% of the LLC and I own 95% of it, and you get a judgment against me. Your sole remedy under Florida law is the charging order, which is an order from the court. It's an equitable order. And the court says, if and when you ever make a distribution from the partnership, Mr. Gassman's 95% of that distribution goes to the creditor. But the judge and the creditor have no power to require that there be a distribution. So now you're at a standstill. Now, the fraudulent transfer statute, go ahead and read Florida Statute 726 if you have an extra 2 hours. It is a meaty statute. It comes from the Uniform Fraudulent Transfer Act. And the bottom line is, for most transfers, the creditor has 4 years to set it aside. And for many transfers, the creditor has the longer of 4 years or 1 year from when the creditor knew or should have known of the transfer. And that 1 year knew or should have known catches a lot of people by surprise, but it can be canceled out by filing bankruptcy. So again, when you're going to make a transfer, because often the best result comes from making the transfer, but you can make a transfer that will be immune in 4 years. You can make a transfer that will lose you a bankruptcy discharge. You can make a bank transfer that was going to have that 1 year look back unless you go bankrupt. You want to work with somebody who knows the difference. So, you know, part of knowing any area of law is knowing what you don't know. So I'm just telling you, that's an area of law that I don't know because I have to look it up every time I get involved with it. All right. Now, the more treacherous liabilities, which don't go away with bankruptcy. You might be able to get a payment plan, but they don't go away. Student loans don't go away. Not paying your wage taxes, taking money out of your employees' wages and not paying them, that's a crime. Don't cooperate or help a client do that. That's called trust fund liability. There's something called the 100% penalty for that. Hazardous waste liability, which is why you should never let a client buy property in their personal name if you can help it, especially commercial property, unless there's been an environmental study. And I've had clients who had phase 1 environmental studies and still had to go clean up the property because the phase 1 study, they don't know what's underneath that property. So commercial property should not be purchased in personal names, ever, 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 ever. But watch out now for the 110% cap. If you own property in Florida, it's not your homestead, it's gone up in value. The property assessor can only go up 10% a year. But now you transfer that property to an LLC, you just blew out the cap. Now it goes up to assessed value. So that's making things more difficult. Okay, breach of fiduciary duty liabilities, child support and alimony. It used to be that property settlement obligations could be bankrupted out. That's no longer the case. You can't bankrupt out properties. And, you know, when you get those calls, oh, I'm about to get divorced, I need creditor protection. No, you need to go see a divorce lawyer. We don't really help people who are going to get divorced. You know, that's just, or see a counselor and try not to get divorced. There's not a lot we can do for you. Just so you know, there's just not a lot you can do for people because family judges have plenary powers, which means that they could just go ahead and put you in jail if they don't like what you did. There's a couple things you can do for a bankrupt, for a divorce, but the best thing to do is to get counseling and don't get divorced. Then Medicare and Medicaid can come after doctors for penalties. So doctors who did bad things or very blatant accidents for Medicare, Medicaid may not be able to bankrupt that out. And then you have the insurance, the uninsurable acts. You almost have to assume that nothing is insurable because carriers will often find ways not to pay claims. So again, you just want to be very careful. So if you're drinking your wine at your office tonight and doing your chocolate tasting, go ahead, take an Uber home, get some work done on the way home, get an Uber that has a light in the back, and bill the whole time. You can bill with a blood level over 0.8, but you can't drive with a blood level over 0.8. Now, forget everything I said when it comes to the IRS, the FTC, the SEC, and family law judges. They are the super creditors and also the Department of Justice getting restitution. Be careful with them because contrary to what I said, if I help a client evade the payment of taxes, it sounds cute. Oh, I owe taxes. This is terrible. My spouse did it all. I'm starving. I've got to protect my children. How can I delay paying the IRS? I am sorry, but I cannot help you with that problem because I don't want to lose my law license and I don't want to go to jail. So just send them down the road, or they can go ahead and file a bankruptcy. And then in bankruptcy, they'll get a payment plan and the government can be nicer. The IRS actually answers your phone calls when you're in bankruptcy. You can actually talk to them. I once had a client who went bankrupt just so the IRS would talk to him because the collections people in the bankruptcy court, at least here in Tampa, are a lot easier to work with than a lot of the IRS collections people. And they actually have phone numbers. So the next step is to talk to your clients about what their choices are. And we always like to put together charts. And I apologize, this is an outdated chart, because this should say spouse 1 revocable trust, spouse 2 revocable trust. And the first thing to remind them is, don't put anything in your revocable trust if you want to protect it from assets. Even experienced lawyers come to me and say, oh, I'm getting sued, but I've got it all in a revocable trust. I'm safe, right? No, 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 not at all. The revocable trust is not even like a thin raincoat for a thunderstorm. In fact, it will hurt you, because that Florida statute 222 that says life insurance protected, annuities protected if they're in the name of a person. A revocable trust is not a person. There's no cases on this, but I have a concern that if you put any of these things in a revocable trust, then the exemption will not apply. So the husband in this situation will own the annuity. He'll own the life insurance policy. If you want to be super safe, he'll own the homestead, because you do have that one crazy old Jacksonville bankruptcy court decision by Judge Proctor that said a homestead is not protected in a revocable trust. The decision was wrong, and it's been criticized by many decisions going the other way. But do you want your client to have any tiny bit of doubt? Not if my client's a neurosurgeon. For the homestead, I'm going to use a ladybird deed. I'm going to put that homestead in his name with a ladybird deed, which says, I hereby transfer this homestead to my revocable trust on my death unless I reverse this deed. That's called, I call it a ladybird deed. So many people call it an enhanced life estate deed. Now, of course, be careful on homestead. If the person has an adult, a minor child, then homestead vests at death in all those lovely children, whether you like them or not. Or if the person has a spouse who hasn't waived the homestead inheritance right, then of course you get a life estate in the spouse. It can be messy. So normally, if it's a married couple, the homestead is going to go into tenancy by the entireties, and you're going to have double protection of the homestead. First, because of tenancy by the entireties, or if somebody manages to sue both spouses, then you're going to have that homestead exemption that I talked about. So I'll mention the bankruptcy code has a 10-year look back on fraudulent transfers to homestead. But that doesn't apply to fraudulent transfers to tenancy by the entireties. So someone's suing me, I own my home, I put it into tenancy by the entireties with my wife, I go bankrupt 5 years later, and now the 10-year look back on homestead doesn't apply. And there's other rules on homestead. You have to own it 1,215 days. You got to live there 720 days, or you have to live in Florida 720 days. All these rules that you can look up if and when it ever hits the fan. Okay. Now on the far right-hand side, you've got the SLAT. I'm sure you guys are so tired of hearing about spousal limited access trusts, but just look at it as a creditor protection device. Spouse 1 is a neurosurgeon. Spouse 2 is a pediatric surgeon. Spouse 1 puts $1 million of his earnings into a lifetime bypass trust, which will be held by spouse 2 for the health, education, and maintenance of spouse 2 and the descendants. This happens before anyone has sued neurosurgeon. $1 million, and whatever it grows to is absolutely creditor protected. Absolutely. Why? It doesn't belong to spouse 1. He gave it away. It doesn't belong to spouse 2. She only can access it for health, education, maintenance, and support. So that is their safest asset. They don't have to buy an annuity. They don't have to buy a life insurance policy. So that's another, that SLAT. I was doing SLATs for people who had no estate tax issues whatsoever. That slat is quite wonderful. What can be more wonderful under Florida law for the right occasion, if spouse 2 has a short life expectancy, then instead of a slat, you can do a lifetime Q-tip trust for spouse 2. It will pay all income to spouse 2 for her lifetime. And on her death, it can be held for the lifetime health, education, and maintenance of spouse 1. And it's not considered to have been gifted by spouse 1. See, if I make a gift to a trust, then under the British common law, which was adopted by the state of Florida when it became a state, did you know that? When Florida became a state in the 1800s, they adopted the English law of the British common law of England, effective 1776. So we don't need a statute on the books here. You go to the English common law. And the English common law said, if you set up a trust for yourself, your creditors can reach into it. Set up a trust for somebody else. And that's why a slat will not be protected from creditors. But what if we do reciprocal slats? My wife, Marcia, and I do a slat. She does a slat. We follow the U.S. v. Grace, U.S. Supreme Court case. We make them just different enough that under U.S. v. Grace, my slat's not supposed to be subject to estate tax in her estate. Her slat's not supposed to be subject to estate tax in my estate. Well, guess what? U.S. v. Grace, the U.S. Supreme Court was not told about the common law reciprocal trust doctrine that applies to allow creditors into those two trusts. Now, if I set up a trust for Marcia, and Marcia has a terrible creditor situation, and that creditor finds out that under the 1950 Delaware Security First case, that they can reach into that trust that Marcia's a beneficiary of and get into that trust, then don't I also have a problem with Internal Revenue Code section 2036A that Marcia is considered to have set up that trust, that creditors can reach into that trust, creditors of Marcia? And the IRS ever learns about this, please no one here tell them, I predict that there's a big risk that US v. Grace is going to be overturned in the tax court by simply saying that, and that's why our law firm does not do reciprocal slats. If we're going to do anything close to a reciprocal slat, it's going to be in an asset protection jurisdiction. And because we don't know yet whether a domestic asset protection court will follow a US judgment, we do not tell our clients that domestic creditor protection trusts will work. And we try to make it very difficult for the client to even be a beneficiary of a trust that they form in another state. And we also provide that upon resignation of the trustee or the string of trustees in that trust in the other state, that trust will have a foreign trustee so that it will become a foreign trust to be protected by the foreign jurisdiction. Clients often say to me, how come you don't charge as much as many other law firms for these domestic asset protection trusts? And my answer is because I don't tell you that they're going to work, because I'm not sure if they're going to work. Now, I know from experience that creditors normally assume that they work and they normally settle cases. And I know from experience that it's a lot safer for somebody to have a domestic asset protection trust than no protection at all. But I'm not going to promise anyone that they're going to work, and they're going to be a belt and suspenders. So I'm going to have an LLC owned in part by a Florida irrevocable trust for the children, owned in part by the Domestic Asset Protection Trust. So if you break through my Domestic Asset Protection Trust, all you're going to get is a charging order. Those are the types of things that are the nuts and bolts. Okay. Clients want to avoid probate. They got that free lunch. They definitely want to avoid probate. They want a revocable trust. They want protection. Can a TBE revocable trust be created to protect assets and also protect from probate? My opinion is yes, but Judge Gentleman in the Middle District Bankruptcy Court has issued some pretty powerful opinions. She's reviewed trusts that would not qualify as TBE, but she said in her language, you can't own TBE property in a trust because you're a trustee, you're not a person. Now, I strongly disagree with her, but I am not a judge. So I'm not sure what would happen if she reviewed one of my trusts, because my trusts say that the married couple owns the beneficial ownership of the trust as tenants by the entireties. So just be careful. Almost every trust we review that says it's a TBE trust has a fatal flaw where one of the unities isn't there. And we also, when we review LLC operating agreements, which purport to allow tenancy by the entirety's ownership, probably 1 in 5 has a fatal flaw. If you don't obey the unities of tenancy by the entireties, which is easy to get mixed up in, then you're not going to have that creditor protection. So here's a very common situation here on page 17. You've got a married couple, and they come to you and they have $3 million of TBE assets, their brokerage accounts. And one spouse is a doctor, the other spouse is a teacher. And they say, are these assets protected? Well, the answer is they're protected right now. If you put them in TBE and the teacher dies, now they're in the names of the surgeon and they're not protected. And by the way, if the surgeon remarries, then they're really not protected. That next spouse may get them. So we could put them in the name of the teacher or in the teacher's revocable trust. Now they're protected from the surgeon's creditors, but if the teacher's in a terrible car accident, that doesn't sound good. But it's really good, though, to have it in the teacher's trust, because if the teacher dies first, then we can make it a credit shelter trust for the health, education, and maintenance of the surgeon. So we don't know what the heck we're going to do. And the answer, which is not entirely shown by this slide, so I'll send you guys a replacement slide, but the answer commonly is to have it set up an LLC, put these things into the LLC, and then have the LLC owned 45% TBE, 45% living trust of the teacher, and 10% by the trust for the children. So what happens? They both get sued. At least you have charging order protection for 90%. Teacher gets sued. Teacher dies, surgeon gets sued. You've got charging order protection for 45%, and you've got credit shelter trust protection for 45%. Teacher dies first, credit shelter trust protection, 45%. So that's a very common thing. Now, the LLC, in my opinion, and according to the portfolio and for Bloomberg B&A, is disregarded for income tax purposes. No income tax needs to be prepared for that LLC. In addition, there is a RevProc, a revenue procedure issued by the IRS, which says that if you should file a partnership tax return and you don't, there are no penalties and no interest if it's a small partnership and all the taxes got paid by the partners the same way that would have been if there had been a partnership. So if anyone wants that information, we have it. Do not put S-Corp stock in that LLC, though, because if the IRS takes the position that it should be taxed as a partnership, as it unfortunately does in the instructions to the Form 1065, then you could lose your S election, and that's a really bad thing. Keep in mind, you could put S-Corp stock into a domestic asset protection trust, but you lose your S election if it goes into an offshore asset protection trust. Okay, well, here's the one I wanted to show you. This would have worked for the Flintstones. Page 21, This is what you can show your client as to what you recommend instead of just tenancy by the entireties. And one thing I really like about this is that, clients come to me all the time. Is my account protected as tenants by the entireties? Well, did you both live in Florida when you opened it? I'm not sure. Were you married when you opened it? I'm not sure. Did you check the box for tenancy by the entireties? I'm not sure. If there was no TBE box, did you check right of survivorship, or was there a TBE box? Was it a Florida account? Well, I don't want to worry about all that stuff, to be honest. I can draft a beautiful LLC operating agreement, set up a new LLC, put all those assets into the LLC, tell them to put their future accounts in the LLC. They don't have to bother me every time they open an account now, and then they can do their annual gifting with the gifting trust. And the gifting trust can pay expenses for their children and their in-laws and their cousins and their church. You can make all those things beneficiaries of the trust, make it disregarded for income tax purposes by giving them the power to replace trust assets with assets of equal value. And you've got a really nice thing going there. It could even be a slat if Fred, in this example, funded the trust. It could be a slat for Wilma, and it can own 20%. And then you're going to have that charging order protection. There are so many things I'd like to mention. I wish I had 6 hours, but I only have these few minutes. Here is an excerpt from a letter I wrote to the client Tuesday. And I said, wow, this is a good letter. Put it in the slide. And the client did email me back and said, good. How do we go forward with the LLC? So it's a good thing to always think of all of the angles. So here's a single client, non-married. You've got IRA, 401k, annuity contract, permanent life policy. If you want to be super safe, you could put the term policy in an irrevocable life insurance trust. And then Florida, I've not mentioned it yet. We have a wage account statute. I almost wish we didn't. But the wage account statute says that the wages of the head of household working for an arm's length employer are exempt. And if you put them in a bank or brokerage account, they're exempt for up to 60 days. And then you can move them into another protected type of asset. And that receipt of the check from your employer and moving it into an annuity or other asset is not a fraudulent transfer. But you have to be the head of household. And that means you need to be supporting somebody else. And if you work for yourself, you have your own professional corporation and it's a small arrangement, like two dentists working for themselves, it doesn't work according to the case law. Even though the court decisions are wrong, that is what the court decisions say. So the professional practice, get a big loan against the assets of the professional practice, get a big loan against the building, and then cross-collateralize the assets of the professional practice with the assets of the building, so that if the professional practice gets a big judgment against it, the bank calls a default because the professional practice is a guarantor of the mortgage loan. And then the bank comes in, collects the accounts receivable, sells the furniture and equipment to your best friend, and the creditors get nothing. You put the professional practice into bankruptcy, you get it appraised. It's not worth much if you're not going to work there. The judge allows the court-approved sale. And if you have a court-approved sale, then the doctrine of successor liability doesn't apply. So when clients say, oh, I'll just shut my company down, start a new one. No, you've got the doctrine of successor liability. The only way out of the doctrine of successor liability is to hope that the creditor lawyers don't know about it. Believe it or not, some of them don't go there. But if they do go there, you've got to bankrupt out the company to allow a court-allowed sale under Bankruptcy Code Section 362. That is the only way to get rid of the doctrine of successor liability. So this single person also puts their stocks and bonds in an LLC or FLP, their real estate in an LLC or FLP, and you layer the ownership between a trust for their descendants and offshore or domestic creditor protection trusts. So I am at 7:22 here. We've got 8 minutes left, which I know for most of you is 3/10 of a billable hour. Are there any questions so far besides whether I'm going to finish on time?
I had a question, Alan. When you were the slide you were just showing the single professional. Could you just go back to that real quick? I don't know if you yeah, it was that one. Okay, so
Yep.
down where you say real estate FLP, you have Homestead separate, so you're not talking about Homestead clearly. So real estate, you're saying other investment real estate not related to the professional building?
Right. Well, most, over here on the bottom right,
Yeah, that one.
I typically set up an LLC, which I call the real estate LLC or limited partnership. And then I encourage them to put each property into a separate subsidiary LLC.
Separate LLC, okay.
Because if building one has a huge problem, I don't want to lose the rest.
Right.
So the LLCs are disregarded for tax purposes. And then this LLC is a buffer. And I don't like to put securities into the real estate LLC because they may make a mistake. They may put real estate under this LLC, or they may have this LLC manage the real estate. So if it's a substantial client, I'm going to have them separate. The other thing I'm going to do is, for most of my clients, these entities are in Wyoming. They're not in Florida because my clients want privacy. Did you know you can Google SUNBIZ and your client's name and the Sunbiz page for their corporation comes right up. You don't even have to know to go to Sunbiz.
Yeah.
So Wyoming does not disclose the manager or the owner or really anything about an entity other than the registered agent. And Wyoming has charging order protection and tenancy by the entireties characteristics equal to Florida, equal to Delaware. I don't like Delaware because Delaware charges a lot, and quite candidly, they're a little bit hard to work with. They're not courteous on the phone. Wyoming, they're very nice.
And the Wyoming entity can own Florida real estate without.
If it's not doing business in Florida, it can. So it can own the vacation home, it can own a vacant lot, it can own property that's triple net leased without registering in Florida. If it's doing business in Florida, it has to register in Florida. And if it registers in Florida, you lose the confidentiality.
Right.
So when clients already have their entities in Florida, or they have to have the entity in Florida, I will form a very simple Wyoming, Colorado, or Delaware LLC, and then make that the manager of their entity. So now when people search Sunbiz, the client's name doesn't come up. The people see the Wyoming LLC as the manager, and then they go to the Wyoming LLC, the Wyoming website, and they really can't get any information. So maybe they stop there. The other thing we commonly do.
Speaking of stopping there, I know you have a lot that you can share, but I do want, because I didn't have the gallery view on, and I wasn't sure if anybody had questions. I don't mean to dominate the question and answer portion. So if anybody has a question, you can go ahead and unmute yourself, and or if you want to raise your hand. I'm trying to look to see if anybody has a hand raised or anything. I'm not seeing any, so I'm not sure if people are just.
Question.
Yes.
Hi, my name is Evelyn. Just a quick question. Does an LLC owned by a TBE trust or a joint trust considered multi-member, or is that still single member?
No, the fiction of tenancy by the entireties is that the married couple is a single entity. Even though it doesn't always feel that way, does it?
Got it. Thank you.
Great question, Evelyn.
Alan, I have a question. So you said that we cannot transfer the life insurance and the annuity to the trust, the revocable trust. I mean, or make the trust the owner, but we can name beneficiary. The trust is a beneficiary, right?
That is absolutely right. You would name the trust the beneficiary. That's exactly what you would do. Yeah.
Okay, and that for the single person with a homestead, you said that we can do a labor deed to transfer the property.
That's right.
Okay.
That's right.
Wanted to
That's what we commonly do. That way you get the probate avoidance done.
Perfect. Thank you.
Right, wonderful. Now, I know that some of you are staying on for the chocolate tasting. Ricardo has joined the Zoom to help us out and walk us through that wonderful treat for those who are joining that. But before we do move on to that, I just want to give another minute or two if there are any other questions. And also, I would really like to just thank you, Alan, for the wonderful presentation. The excellent slides, the clear explanation. I found it very useful, and I'm sure that many of our members did as well. So we really appreciate you taking the time and joining us and giving us this presentation. Does anybody
Yeah, I
else
was glad
have
to
any
do it.
other questions? Sorry, let me cut you off.
I have a question, Alan. This is Candace Boldy. So you said that that even if you're being sued or even if you know of a creditor, you can put everything into your homestead and it's protected. So you could go and sell a bunch of your assets and use the proceeds and put them into your homestead.
Yes.
And are there any limitations like on what I know you went through some of the limitations on what you're being sued for. But like if you got arrested for something, I'm dealing with a client that got arrested for something, and I'm wondering if there's any limitations based on what you were arrested for. It doesn't matter.
It doesn't matter. It doesn't matter. In fact, you'll find the case where the couple was back when it was very, very illegal. They were growing marijuana on the property, and then they wouldn't let the government or the creditors take the property while the people were in jail intending to go back to the property. Now, the biggest exception to this is if you put what we call ill-gotten gains into the homestead, then whoever you swindled out of those ill-gotten gains can get it back. So there's one bankruptcy court case where a man made a fraudulent transfer to his girlfriend and said, wow, take this money, my creditors can't touch it, buy a house with it. So she went and bought a house with it, and Judge Williams here in Tampa said, no, that's ill-gotten gains. That was bad money. So you've got to track the money. If the client's getting money from a business that the FTC doesn't like, and all the investors are going to sue the client, they need to buy the homestead with their old cold money, not the money that they received in something that may be criticized or a Ponzi scheme, something like that.
Okay, great. Thank you.
I'm going to have to stop us there. Alan, thank you very much. We really appreciate your presentation, your time, and wonderful. This is being recorded at your request. Thank you for suggesting it.
You're one of the best. You're one of the best moderators I've ever had. And if you guys want me to come back for part 2, or if there's anything I can help your chapter with, please let me help you.